matter of title, block holdings, limited, and others in Okunola.
Yes, good morning.
Good morning, my lord and my lady. I appear, as on the last occasion, with my learned friend Mr. Field. The respondent, Ms. Okunola, appears in person, and my learned friend Mr. Donmore appears as advocate to the court. I hope the court has 3 bundles in single PDFs. We should have 1 authorities bundle, 1 supplementary bundle, and 1 core bundle.
Yeah, we have literally millions of bundles, but I think we've got the ones you've sent us. Thank you.
Thank you. There was also the single authority which was brought to the court's attention yesterday by my learned friend Mr. Donmore.
Thank you, we've got that.
Yeah. May it please the court, the narrow issue on this appeal is, or perhaps I should say was, whether the High Court has jurisdiction at the application of one party to litigation to restrain another party from communicating with the lawyers representing them in that litigation in a way that interferes with the proper conduct of the litigation. Now, the indication in the note from the court following the adjourned hearing is that the court is minded to rule in principle that the High Court does have that jurisdiction. And so, bearing in mind what is said in the court's note, which for your reference is in the supplemental bundle at 251, I will today address 4 broad topics. The first topic is, what are the potential jurisdictions for the type of order sought by the appellants before Mrs. Justice Hill? And I should add that when I refer to jurisdiction, I mean source of the court's power. The second topic is, which of these jurisdictions did the appellants rely upon before Mrs. Justice Hill? The third topic then will be, could and should Mrs. Justice Hill have made the order sought? And the fourth topic will be, if so, should the Court of Appeal make the order sought as reformulated? And my lords, the first 2 of these 4 topics are the ones that will detain me, and I suspect the court, the longest. Submissions on the other topics in the court's note concerning procedure, evidence, indeed the test to be applied, and other considerations in my submission will flow from the conclusions on the precise jurisdiction the appellants base their application on. My lord?
I mean, power, let's talk about power.
Yes.
Jurisdiction is apparently a confusing word.
Fine.
There is power for the court. There is an inherent jurisdiction in the court to protect its own procedure, and there is power to protect its own procedure in the interests of justice to grant an injunction. It's not controversial.
No.
I mean, we can ask Ms. Okunola what she says, but I don't think that can be controversial in the light of authorities. The purpose of the note was to draw to your attention that in exercising that jurisdiction, and the cause of action rule has been abolished, right, effectively. We know that from paragraph 43 of Wolverhampton. So, the purpose of the note was to draw to your attention that there are perhaps 4 serious questions, impediments that have to be considered before such an injunction can or should be granted. Your point 3. Right. And we would value, which was the purpose of the note in October, argument on how they impinge on the way in which the court, in first instance, should approach that kind of application. And the 4 impediments are as follows. 1, the absolute immunity from defamation and perhaps other proceedings enunciated by my lord in Iqbal and by the Court of Appeal in Iqbal. Secondly, Article 10. Is it engaged? And if it is, what is the answer to Article 10.2 and the proportionality exercise thereby required? And thirdly, really, what is the relevance of the fact that there are perfectly good statutory procedures enacted by Parliament for protecting people from harassment, and that, as in Abassi, the solicitors in this case could have brought those proceedings but chose and choose not to. And then finally, what factors should the court take into account when deciding, in the light of all the above, whether or not to protect? Is it the biggest law firm in the world or the biggest commercial law firm in the world from harassment by Ms. Okunola? Now, those are the questions that the court asked you about. So to spend a great deal of time taking us through Wolverhampton and Abassi and PMC, with which we're pretty familiar, is absolutely fine. You will take your own course. But those are the things I think we said we were interested in hearing about, because they impinge on the question that you do want to answer. Could or should Mrs. Justice Hill have made the order? We know she could in theory, but should she? And should we now make an order as sought by you? So I'm not going to spend a lot of time talking today. I'm going to try and keep quiet and listen. But I wanted you to be clear that those are the things that are in our head.
I'm grateful for that indication. My Lord, the court did ask us whether the different sources of power were different. And so I think it matters the exact power that the appellants asked or have asked the courts to exercise in this particular instance. The outline of my submissions on that, and it may not be necessary in light of the court's indication to go into much detail on those topics, but the starting point is that the very granular analyses in the cases that your Lordship has just referred to is that the courts have powers under several discrete jurisdictions to grant interlocutory relief that is non-dispositive of a substantive adversarial claim.
But you were asking for a final injunction.
In effect, well, I am using that convoluted formulation because I don't want to adopt, as it were, the Section 37 terminology. Some of the orders with which that we are dealing with and that are referred to in the authorities are not interlocutory in the sense that they are made pending the resolution of a substantive claim, but nor are they final in the traditional sense of, as it were, resulting from the resolution of a substantive claim before parties before the court. There is discussion of what the meaning of interlocutory is in Lord Legate's judgment in Broad Idea at paragraph 77 at page 874 of the bundle. I'm slightly careful to adopt that terminology because obviously it's a term of art in relation to equitable injunctions. It is also my submission that it also follows from these authorities that the distinctions between these various powers matter. And so an applicant for relief and the court considering the application needs to be clear which of the potential powers are relied upon. And so there are some important distinctions to be made. And the first one is that between the jurisdiction that is inherited from the High Court of Chancery to grant equitable injunctions, now enshrined in statute in Section 37, and the so-called inherent jurisdiction. And in relation to the former, and quickly in answer to a specific question in the court's note, I would submit that the Broadmoor jurisdiction is an aspect of the court's equitable jurisdiction. And in relation then to the court's inherent jurisdictions, in my submission, the authorities before the court require a further distinction to be made between two sources of power. The first one can be referred to as an inherent protective jurisdiction. And this term covers, in my submission, the powers that the court has when it...
Sorry, you're going to have to say that again. I don't think I followed you.
Yes.
Can you just go back one sentence?
So there is a distinction within what is referred to in the authorities as the inherent jurisdiction.
Yes.
And on the one hand, we have what I refer to by shorthand as the court's inherent protective jurisdiction. And this, in my submission, covers the powers that the court has when it acts not in its adjudicative capacity, but in its protective capacity. And the clearest example of that is, of course, the court's equitable parent petria jurisdiction, which is discussed in Abbasi. But I am hesitant to say that Abbasi type jurisdiction is the extent of it, because as this court made clear in PMC, in cases such as Dartford, when the court exercises a protective jurisdiction, but which is not of equitable origin, its powers are in a similar category. And so the precise power...
Sorry, you've said there's a distinction within the inherent jurisdiction between an inherent protective jurisdiction covering the powers that the court has in its protective capacity and what?
And the inherent judicial jurisdiction, as I will refer to it. And that is simply to distinguish it. And that is the line of authority which is discussed in the case of Tempest and going all the way through, which we rely on in the case of Connolly. So the traditional inherent jurisdiction. That needs to be distinguished from the jurisdiction that is exercised in Abbasi and also in Dartford. And these, as my lord pointed out earlier, these are the powers that the court has that are necessary for any court to function properly as a court in the interest of justice.
So what's the distinction?
Process.
What is the distinction?
The distinction between the protective jurisdiction and the traditional inherent jurisdiction is that first of all, the court is not acting in an adjudicative capacity. Effectively, is not deciding primarily between competing claims. Its role is a primary one, and as described by the court, particularly in relation to the protective jurisdiction, I believe at paragraph 40 of Abbasi.
I mean, you've got to be a little bit careful here. We have a litigant in person on the other side of this argument, and if you use too many shorthands and assume we all have read every authority and understand every paragraph of it, I'm worried about her not understanding exactly what you're saying. And please, Ms. Okunola, if you at any time feel you're not understanding what's being said, I mean, obviously I can't give you a legal education immediately here, but we would be very willing to try and help explain anything that is said by counsel that you don't understand. So feel free to tell me. And as far as you're concerned, Mr. Loof, I would very much appreciate it if you tried to make your language and submissions as accessible as you can, and too many sort of very legal shorthands would be best avoided.
Noted.
Now, I don't understand. The distinction between these two is that the court is not acting in an adjudicative capacity, but in Connolly, it wasn't an adjudicative capacity either, was it?
Well, in Connolly, the court was adjudicating very much on a submission that the court should have the jurisdiction to stay a prosecution, even when there had been a failed submission of, or a failed trial, on a plea of ultra full acquit.
Well, I mean, the passage you rely upon in Connolly is about the court not acting in an adjudicative capacity, but in protecting its procedure.
Yes, and so this is the distinction that I'm seeking to draw is simply this, that the inherent jurisdiction, and it is partly because the same words are used in my submission to denote different powers. But if we go to Abbasi at paragraph 38, which is at page 1200 of authorities bundle.
Yes.
You can see there's a quote from
Hang on a
Viscount
second.
Haldane in
Let
Scotland.
everybody get it. Now, have you got the authorities bundle, Miss Okunola?
I do.
Right. So we're at Abassi in which page?
1200.
1200. Yes.
It's the bottom of page 1200. It's a quote from Viscount Haldane, the Lord Chancellor in Scott and Scott. And just at the top of page, over the page, at page 1201, there's the explanation for the origin of the power that the court is exercising in that case. And what, in these following paragraphs, so paragraphs 39 to 41, what the Supreme Court makes clear is that when it's acting in this capacity, although it may be choosing between options that are presented to it by parties, its function is not to adjudicate in the sense of determining which of these parties is right. See paragraph 41. But of course, to decide what should be done in the best interests of the child in this case. And so it follows in my submission that what the court is doing here, it is that it is not bound by the parties' proposals, but if it perceives that another alternative course of action is in the best interest of the child, that is the one that the court should adopt. And so if we then go to paragraph 66 at page 1209.
I mean, I don't want to stop you, but I don't understand what the reason we're looking at this. Of course, we understand how the parents' patriae jurisdiction operates. We understand that if somebody brings an application for an injunction to protect the process of the court can do what it thinks it should do to protect the process of the court beyond what is proposed by the parties. But without being rude, I'm sort of minded to say, well, so what, obviously?
As long as it is clear that the distinction matters to the appellants on the basis that we are relying on the traditional, and should we say more narrower meaning of the inherent jurisdiction. Given that that is the terminology that is used in Abassi, it is important, at least to me as I stand it, to make it clear that this is a different order of jurisdiction. And because in Abassi, the court mentions potential reliance on both the inherent protective jurisdiction and the traditional, the inherent judicial jurisdiction, the distinction for us matters to that extent.
So you're relying on the inherent protective jurisdiction?
I am not. We're relying on the inherent judicial
jurisdiction.
Yes.
Okay, well, I'm a bit confused, but yes.
So,
I mean, I would have thought you were relying on the inherent jurisdiction to protect the process of the court in the interest of justice.
well, that is true. I mean, but again, we can adopt whichever terminology is most convenient to the court, as long as it is clear that we're not relying on the category of inherent jurisdiction which the Supreme Court was dealing with primarily in Abassi.
It's not parents' patriae.
It is not parents' patriae, exactly. But given the terminology and given the indication in the court's note that we should be precise with the jurisdictions that we're relying on, that is the distinction that I need to draw. And so that brings me on to the inherent judicial jurisdiction.
Sorry, you mentioned paragraph 60-something. What was
Paragraph 66.
66.
Yes.
Yeah.
And if the court, paragraph 65, has made it clear what the limits of the parents' patriae jurisdiction are, in the sense that they come to an abrupt end when, in this case, the child is no longer in need of the protection of the court.
So what do you say? You say the judicial jurisdiction doesn't come to an abrupt end when the proceedings are over, do you?
Well, no, and I will get back to that in the sense that the authorities say that the court, in exercising its protective or its inherent judicial jurisdiction, can indeed provide protection for future proceedings. It's indeed something that this court referred to in PMC. But the point made here in Abbasi is that there is a distinction, paragraph 66, that the same effectively material remedy can be provided using different powers. Mention is here made of the Broadmoor jurisdiction, or that it is an equitable jurisdiction that can take over, and I would say the traditional equitable jurisdiction to grant injunctions, or indeed various powers that would be available at the suit of the clinicians. So if I go then to the jurisdiction, which is the one that we rely on, so say the court's inherent judicial jurisdiction, in PMC, this very court referred to this jurisdiction as the inherent common law jurisdiction of the court to protect the integrity of its proceedings in the interest of justice. That's paragraph 103 at page 1279 of the authorities bundle. Now,
can we just look at that?
Yes.
Paragraph 103.
Yes, it's right at the bottom of page 1279.
Yeah. The electronic numbers are different from the physical numbers.
Absolutely maddening.
Yes, so we referred to it as the inherent common law jurisdiction of the court to protect the integrity of the proceedings in the interest of justice. And you rely on that?
I do.
Here, too.
Yes. And also the court, you go on to say, my lord, it is not made under either the Paris Patria protective jurisdiction or under an essentially protective court process. The distinction just made.
Mm-hmm.
Now, there is a summary of the basis for the court's inherent judicial jurisdiction, which starts with Cocker and Tempest, at paragraphs 11 to 15 of Lord Phillips, when he was Master of the Rolls, in his judgment in Bamji and Fordstick, and that is at page 538 of the...
Could you give me the tab number, please?
Yes, tab 28. No apologies. Yes, it is tab 28. Starting at page 92 of the report, if that helps.
What's this case about?
So this case is about vexatious litigants.
Right, oh yes, yes, of course.
It's the pre-statutory regime for dealing with vexatious litigants.
Right.
And
which paragraph do you want?
so if we look at it, this summary that I'm referring to starts at paragraph 11 and continues down to paragraph 15. And having gone through the authorities, starting with the exposition by Baron Alderson in Cocker and Tempest, where Baron Alderson says that the power of each court over its own process is unlimited. It is a power incident to all courts, inferior as well as superior. And were it not so, the court would be obliged to sit still and see its own process abused for the purpose of injustice. And it's also clear that he makes the distinction between the equitable jurisdiction of the courts of equity and that the inherent, to refer to the inherent judicial jurisdiction. It says that the distinction between this power and that which is exercised by a court of equity in granting an injunction are not the same.
So where does he say that?
If we go to that judgment is in tab 9 of the authorities bundle.
Oh, sorry, I thought you were saying that Lord Phillips has said that.
No, well, he's quoting Baron Alderson.
Oh, right, okay.
And that quote, if you wanted in the original, is that...
No, I know where it is in the original, but I thought you said that he said that's not the same as the equitable jurisdiction.
Yes. Baron Alderson says that it's not the equitable, it's not the same.
Which page?
Page 59 of the authorities bundle, tab 9. And it's the final paragraph of that report. So it's the final sentence of that substantive paragraph where Baron Alderson says the distinction between this power and that which is exercised by a court of equity in granting an injunction is that the injunction stops proceedings in another court, this only in the court in which the proceedings are. So Lord Phillips in Bamji relies on this line of authority, which you will see if we go back to page 538, 539 of the authorities bundle. Also refers to Lord Morris's statement in Connolly, which we've already looked at. And then he says at paragraph 15, the court has power to take appropriate action whenever it sees that its functions as a court of justice are being abused. And then he says, and this is important for our purposes, the advent of the civil procedure rules makes the nature of those functions more transparent. A court's overriding objective is to deal with cases justly, and this means, among other things, dealing with cases expeditiously and allotting to them an appropriate share of its resources while taking into account the need to allot resources to other cases. And my lords, my lady, I obviously highlight this because of the emphasis that the inherent judicial jurisdiction is exercisable to prevent abuse of the court's functions as they are now set out in the civil procedure rules. And so that brings me on to what the precise jurisdictional basis for the order sought was. If I can then take the court to the application notice, please, which is in the supplemental bundle. Tab 15 at page 404. So we can see there that the application in the upper right-hand corner was made in the existing proceedings. See the case number, and it was made on behalf of the claimants, now the appellants, and by their legal representatives. And then, if I can take the court, please, to the draft order which accompanied the application, and that's at page 526, that is in tab 18. We can see there that it's
518.
Page tab 18, page 526.
526.
Yes. And we can see that there is it's framed in terms of an order. It has a penal notice. And then the first line or the first recital is in my submission where the reference is to the court's jurisdiction or the court's powers, as it were. And the first of those references is the overriding objective, which I don't need to remind the court, but it is to enable the court to deal with cases justly and at proportionate cost. And the second reference is CPR Rule 3.1, subparagraph 2M. And we can perhaps go to that. It's in the authorities bundle, tab 6, at page 18, at the very top of that page.
Which page in the bundle?
It's 18.
18.
Yes, 1-8.
That's the protection. Every bundle is 3 pages out. I would have thought of solicitors of your scale could have got them right. Now, most solicitors manage to get them right. It makes it very difficult with your 3 pages out in each case.
My Lord, I have noticed that this depends on the PDF reader program, that one.
Now, what happens
No,
is
it
people
doesn't.
number from the first page of the first authority, and then they add the index. And there's
Well,
usually many pages of index, so it kicks out.
I'm simply saying that in the PDF program that I'm using, if I type in the number, it has taken into account the index number. So I can only apologise. So yes, it would be
Well,
PDF
everybody else
page
manages
21
it.
then. At the very top of that.
Okay.
So, sorry, page.
Dismiss or give judgment on the claim on the premise.
Yes, my Lord. What I was going to say is that you need to read now. The
So
numbering was
where
changed.
are we looking?
The numbering, top of page 18 of the bundle, so that would be 21 of the PDF perhaps. And since, I think a couple of days after the application was submitted, the numbering in CPR subparagraph 2 was changed, and so now the relevant jurisdiction is now little p, which is at the top of
So what was M is now P.
what was M is now P, exactly.
Okay.
So you can see that if you want, it's footnote 8. The changing happened on the 1st of October. You will
So,
see.
is that the complete set of documents that you're relying on as indicating the jurisdiction invoked?
Not
This
quite.
application? Right. Well, then I'll pause for you to complete that process.
Yes, and you will see that the page P, the court may take any other step or make any other order for the purpose of managing the case and furthering the overriding objective. If we look at the commentary, which is 2 pages down, in the commentary in the White Book, so page 23 in the PDF, page 20 of the bundle, towards the bottom it is section 3.1.13. The editors of the White Book say, as to procedural matters, Rule 3.1, subparagraph 2p codifies, or at any rate duplicates, the court's inherent jurisdiction to make any order which is necessary to make if the court is to act effectively. So in my submission, this aligns perfectly with the purpose as stated by in the authorities as the basis for the court's inherent, open brackets, judicial, close brackets, jurisdiction.
The point, the observation I was going to make for your comment was that we haven't been shown any actual express use of the term inherent jurisdiction in the application documents. Have I missed something, or is it a point that depends on reading the commentary? Is that how one finds out that that's what 3.12p is about for your purposes?
Let me verify whether the word inherent jurisdiction actually features in the application documents.
Because one of the things I noticed when you were showing us the application notice,
Yes.
and this is a common feature of application notices, the box says, what are you asking for and why?
Yes.
You tell us what you're asking for, but you don't tell us why. That comes in the draft order with its reference to 3.12p and then an onward reference to the notes. I'm just thinking of the situation of the judge here.
Yes. Yes, no, I mean, in our defence, as it were, the authorities are perhaps not always consistent in terms of the terminology that is used, whether it is an injunction or an order, and what necessarily follows from the specific power invoked. But in my submission, there is no reference, for instance, to Section 37. There is no reference to the equitable jurisdiction.
Now, where is there no reference to Section 37?
In the recitals to the order, the draft order that was submitted with the application. My lords, my lady.
So what does that mean? It means you do not rely on Section 37 at all?
So I was going to get on to this. Now, you in your note, you asked which of the powers could be, could lie at the origin of the order that was sought, and you will have noted, my lord, that we say at paragraph 3 of our most recent skeleton, which is in the supplemental bundle at tab 5, specifically at page 174. We say that the court's inherent and equitable jurisdictions are separate sources of power, both being adequate to support the making of the order sought. And then we make it clear at paragraph 4, if you go 2 pages down, that the claimants put their applications to the judge on the basis of the inherent common law jurisdiction rather than the equitable jurisdiction, which was ultimately codified in Section 37. And we maintain that that is the most appropriate characterization.
So could you give me the page in the bundle, because my copy of your skeleton hasn't got that paragraph. The page in the core bundle?
No, it's in the supplemental bundle.
Supplemental bundle. Paragraph. Page?
176.
And you referred to paragraph 3 and...
Paragraph 4. My lords, my lady, the respondent has left court. Should I pause?
Yeah. I don't find anything in your skeleton about the inherent judicial jurisdiction.
It is referred to in the skeleton as the in paragraph 4, the inherent common law jurisdiction.
Okay.
I'm just looking at what the judge said under legal framework, and she doesn't appear to have appreciated that your application was under the inherent jurisdiction. Are you saying she got it wrong, or is it really that the theory has developed a little bit since you were in front of her?
I think there are certainly aspects of both.
Okay.
Can I just...
Jeffrey, do you want to stop? Because Okunola left court. Do you want to carry on?
Let me ask the usher.
Yep.
Sorry, just gone to the bathroom. I think we should pause. So we will just rise, I think, for 2 minutes.
Court rise available.
Please let us know when she's returned. Sorry? No, don't carry on with the stream, but just let us know when she returns. So, Mr. Lou, for the transcript and those watching on live stream, what has just occurred is my Lady Justice Whipple noticed that Miss Okunola had left the court. I think she told the usher that she was leaving to go to the bathroom. When I realised that, I'm afraid I haven't got an eye this side, so I didn't see it. She said that she was going to the bathroom, and we rose immediately because we wanted her to hear the argument and understand it, as I'd indicated earlier. Now the usher tells me that she came back into court whilst we had risen and removed her belongings and has apparently left. Now, of course, it's her privilege not to attend the hearing of your appeal. We knew that she might not come because she'd had correspondence with the court, but don't think there's much we can do about it, and I think we are all agreed that we should continue with the hearing in her absence in these circumstances. But I just wanted to record what had happened in case it ever became relevant. Thank you.
I'm grateful. Can I pick up my Lord Justice Warby's question in terms of how the application was put originally in front of Ms. Justice Hill? My Lord, from Mr. Field's submissions, the introduction to them, are in the supplemental bundle, tab 20, at page 535.
So you're going to give me supplemental bundle
Tab 20,
535.
page 535. 538, perhaps?
Oh, this is 538.
It's page 40 of the...
Yeah.
So by the top there, you will see, beginning line 6, there's of course CPR rule 3.1.2m. Should say at that point, obviously, it had changed. It was then P, but it gives the court the powers to make any step necessary. And then line
Is there a transcript of this hearing being prepared?
of today's hearing.
Yes,
Yes,
there is.
there will
Can
be.
it
Yes,
be provided to the court afterwards, please?
of course.
Yes, thank you. We weren't asked. Normally I'm asked, but
May I turn my back quickly just to confirm?
I'm delighted if it is being prepared. Yeah. Good. Okay. So long as we get it, that's absolutely fine.
Yes,
Thank you. It also saves sort of a really, really intense note-taking at some stages. And obviously the strictures that I gave you earlier this morning about shorthand is not quite so serious if Ms. Okunola doesn't wish to listen to it.
My Lord, I'm grateful, and I hope the court has noticed that the transcript of the adjourned hearing is in the bundle.
Right, I hadn't
Yeah.
noticed that.
Well,
I'm sure you'll take us to it if we need to look.
Yes.
But anyway, you referred, as we now see, to 3.12m, which is now 3.12p.
Yes, and then if you go down to line 13, Mr. Field says that furthermore, to the extent necessary, I also rely on the court's inherent jurisdiction to control its own procedure.
Right.
Now, to Lady Justice Whipple's point earlier,
And then, sorry, just lines 24, 25.
yes,
He says, there must therefore be an inherent jurisdiction to make the order that is sought. And then the judge is trying to catch up, and over the page 41, lines 4, 5 and 6, she just repeats back to you and asks if that's right. So there is a sort of, that's how it's put.
yes, my lady, but I have to say, in all fairness, it is obviously the case that the same care that has been taken in identifying the exact powers of the court and the nature that has been taken now were not taken before the learned judge at first instance. It is also true to say that, and this is why indeed why we're here, that the debate, as it were, veered onto the field of equitable jurisdictions because what concerned her ladyship was effectively the extent to which the cause of action rule in the Susquehanna prevented her from making the order sought. And of course, to the extent I need to make it, I don't think I do, but that is a limit which is proper to the court's equitable jurisdiction to make injunctions. And so part of the confusion stems from the fact that there was a mismatch between the way in which the application was originally put and the way it was then had to be defended from, as it were, the challenge that was raised by the learned judge. But
So the Siskina was mentioned in argument.
Yes, it was mentioned in argument because the judge raised it after, as it were, after a break and having taken, we can identify it, but it was
And having looked at Bean on injunction.
indeed.
And she came back and said, this is the Siskina. What did you say?
Can we come back to it? As we said, as the arguments that were made following research, as it were, we said that the Siskina doesn't apply anymore from broad idea, but also that it was part of the category of exceptions that had already been made in any event to the types of in the injunctive power. But I think the point, and I think just in fairness to how matters developed in argument in front of the learned judge, it is right that it wasn't, should we say, perfectly clear what the consequence of what the power in the end that she was purporting to exercise and that she considered that whether she had the power to exercise was. I think that is fair.
And it was being presented, according to the transcript, as not in substance an injunction, but merely a case management direction to enforce the overriding objective.
Quite.
Which is a rather unusual way to put it,
But
because it carries with it the risk of contempt.
yes.
And it's an order restraining someone from doing something. Looks and feels like an injunction. Yeah. I mean, I don't think the judge was misled by that, because she treated it as an application for an injunction. But there seems to have been, if I may say so, a degree of fuzziness about the nature of the order that was being sought and the source of the court's power to grant it. Would that be unfair?
No, my lord, I can't say that that's unfair. I would say not in the way that it was put, but perhaps it got confused during the course of argument.
Because there's also this point, the procedural point, which is not the most important point in the case, but is a point. That it was being said, well, you don't need to worry about whether this is interim relief that you would grant, because it's restraining speech, because we're seeking a final order. That was the first point. And secondly, anyway, whatever the test is, it's met. Second point I could see, but the first point may be debatable. Thank you.
As you will see in terms of now, in the skeleton, we rely principally on the power and the way it was originally put before Mrs. Justice Hill, so part of the inherent judicial jurisdiction. But we say that in theory, the power could also be exercised under the traditional equitable jurisdiction to grant injunctive relief. And the reason we say that is because as a starting point, it is difficult to say that the court would not have this power under its equitable jurisdiction. The now, should we say, established formulation of the equitable jurisdiction is that it is in principle unlimited, subject to any statutory restrictions. One of the formulations you will find at paragraph 98 of Abbasi, that is, for your note perhaps more than anything, 12.8, page 1218 of the authorities bundle. And as for the justification or the potential justification for its exercise in this case, we say that the appellants obviously have a right of access to justice, and we say that the defendant was engaged in conduct that was unconscionable on two levels. The messages were themselves unconscionable, and secondly, they were sent with the apparent objective to thwart or at least interfere with the appellant's exercise of the right of access to justice. And we say that that is clear from correspondence from the respondent in response to the application for the order at issue. And with that, if I can take your lordship, my lady, to supplemental bundle, tab 19, at page 528. So 531 of the PDF. So you will see if you go to the bottom of that chain, which is page 530, so page 533 of the PDF.
Sorry, 523 in the PDF.
533 is the bottom of that chain. Page 530 of the bundle, you will see that this is the email by which Quinn Emanuel served this application on Miss Okunola. She then responds, and in fairness to Miss Okunola, she is the one who raises the cause of action point. That's top of page 530. Dear Quinn Emanuel, please advise what the relevant cause of action is with respect to this interim relief you are seeking. And so if we go back...
She says exactly that you had to bring a new claim and pay the fee, right?
Yes. But if you see at the top, and this was the reference that I was taking your lordship, my lady, to, top of page 528.
I mean, this just to look at this document here, Dear Quinn Emanuel, you see that where she raises a substantive point, which I'm sure you could not injunct her from raising in the process. This epitomizes why the question of the immunity is relevant, and why in exercising the undoubted power to grant the kind of injunction you seek, it is difficult to separate, and needs to be done on the facts, the abuse, there is some kind of abuse here in the fourth paragraph, but there is also a substantive legal point. And litigants, of course, do this, litigants in person, they combine and don't make distinctions that lawyers would make. But it might be said against you that actually paid lawyers have to simply fill it out, the bits that are relevant, respond properly to the suggestion that as a matter of law you should have issued a new claim against her for this relief, and ignore the abuse, if that's what it is, in the fourth paragraph, and the stuff in the fifth paragraph. I mean, it's a sort of good example, isn't it? I mean, some of the documents I've seen, of course, are just abuse. But you can't come to court and say what you want to be injuncted without also saying what exercise the court has to go through to decide if the injunction is in appropriate terms and will actually fall within either a contempt or an immunity or Article 10.
Yeah, my lord, just to be clear, the appellants have never relied on this piece of correspondence as an example of the type of correspondence.
That's not the point I'm making. It's not that you come and say, I am showing you one abusive or 10 abusive or 100 abusive emails, and these emails are all very abusive. It's that the situation where you are asking for a blanket injunction that would, I imagine, prevent this email being written in the form it is complicated.
Granted, and perhaps, my lord, we will come back to this when we deal with whether this order should have been granted by Mr. Justice Hill. But you will see in terms of how my lord suggested it should have been dealt with by the claimants at that stage, the appellant here, it was indeed what was happened. They explained that we did not need to issue separate proceedings. And the email that I was going to take you to make the point that there was an underlying objective of making this litigation as difficult as possible for the claimants at that stage.
Yeah, I thought that was your point. That you referred us to this document in support of the proposition that there were three things that founded the exercise of the jurisdiction in this case, the right of access to justice of the appellant, the inherent likelihood that the material complained of would interfere with access to justice, and thirdly, the apparent objective of achieving that. I think that's where those were the propositions for which you referred us to this material. I was just trying to understand which bits of it
Yes, so
you were relying on for those second and third.
to recap, we're saying that the basis is that we have the appellants, the claimants at this stage, had a right of access to justice, and that the conduct that was engaged in, that was relied upon, was unconscionable. And we say that the unconscionable nature of the conduct is established on two levels. First of all, on their face, the communications were unconscionable. And secondly, they were sent with the apparent objective of thwarting or at least interfering with the appellant's exercise of the right of access to justice. And if you see this email at the top of this chain, is that there is an underlying objective here from Ms. Okunola, effectively to come to a settlement.
So
In
what's
return-
which email are you referring to?
Right at the top, at page 531 of the PDF, page 528 of the bundle. If you do not want me to make truthful disclosures about Yasin Gailani's and your conduct during these proceedings, I'm willing to agree a non-disclosure agreement for a sizable amount of money.
Oh, I see.
Now, in Wolverhampton, at paragraph 160, so if we go to the authorities bundle, tab 50, at page 1133, Supreme Court says that protection of the court's process from abuse or preservation of the utility of its future orders may fairly be said to be the bedrock of many of equity's forays into new forms of injunction.
What paragraph was that?
Paragraph 160.
Thank you.
I'm sorry to go back to this point about the correspondence.
Yes.
I think what you're saying is that the court is entitled on an application made under Part 23 to reach a final binding conclusion of fact that this sentence is evidence of an intention to use abusive correspondence to thwart or interfere with the right of access to justice of the claimant. Is that right?
That is right.
Without cross-examination?
There was the defendant at that stage, the respondent in these proceedings, was always in the ordinary course of things able to put witness statements as well as submissions in response to the claim or in response to the application.
It's quite important, this, because generally speaking, procedurally, findings of dishonest or other seriously wrongful conduct are not made without being formulated clearly, put to a person so that they can answer them, and allowing them a fair opportunity, which commonly, if you're asking for final and conclusive determinations, is done by way of some trial process, which would tend to support the point that Ms. Okunola was making in this correspondence. It's typically said on applications for interim injunctions that the court shouldn't determine disputed issues of fact unless it's able to do so conclusively without the need for a trial. It's a summary determination that you were seeking of quite a serious factual issue. Just highlighting that one of the difficulties that I see, potential difficulties that I see with doing this in this procedural fashion.
I mean, this is again in the framework of the extent to which the court could find that the behaviour was unconscionable, that the conduct that
Yeah, well, I
was
don't
relied upon was
myself
unconscionable.
understand what you mean by unconscionable.
Yes.
Because it means whatever someone in the court's conscience might say is wrong, but that's why I reformulated it as having a tendency to interfere or would likely to interfere with the access to justice. But what do you mean by unconscionable?
Unconscionable in as a contrary to conscience. It it would be just and convenient for the court to make the order on that basis.
But that's, it's confusing a whole host of concepts. You don't make injunction orders because somebody in a proceeding says something unconscionable. I mean, she's written just take that example, that letter. It's a very good example of the kind of thing, no doubt, you had to put up with. She makes an extremely good point, maybe right, maybe wrong, but it's a perfectly good point to make in the litigation, and then combines it with some abuse, common abuse. Whether that's unconscionable or not unconscionable doesn't matter. It's certainly abusive, and makes allegations. But, litigants in person behave like that all day long. And we are being asked in this case to say, according to your opening submissions, when the court should restrain that conduct. And we cannot do that without looking at the free speech rights that people have under the European Convention on Human Rights and under the common law. So, as I say, using sort of loose language, as my lord has pointed out, doesn't help us to answer your third and fourth question, which is where this case really turns.
The submission that I was building up to is that we say that there was a potential power under the equitable jurisdiction to grant injunctive relief for the order that was sought. But we say that we maintain that that is not the appropriate basis for the power, and we only seek to justify the order on the equitable jurisdiction in the event that this court was to find that the inherent jurisdiction does not give the court the power to make orders of this kind. But if the court takes the view that the inherent jurisdiction is wide enough that the court has the power in principle to grant the relief sought, I personally struggle to see circumstance in which the equitable jurisdiction would have a role to play. Not least because it's a residual jurisdiction, but more substantively, if the court concludes that the order was or is not justified in the circumstances of or under the inherent jurisdiction, it is difficult to see how the court could conclude that it would be just and convenient to make this order under the equitable jurisdiction. And we say that the choice of the court's inherent jurisdiction as the basis for the application has three major consequences. And the first of these is that the court's inherent power is not residual, in the sense that it's not ousted by the existence of potential alternative routes to the concrete relief that is sought.
So you've got to say that more slowly.
Yes. The court's power under the inherent judicial jurisdiction is not residual, in the sense that it's not ousted by the existence of potential alternative routes to the relief, the concrete relief that is sought. And I will come back to this, if I may, shortly. And to make good that proposition, if we can go to the authorities bundle. Again.
I mean, that's obvious, really, that it's not ousted. But that's not the question we asked you. And it's not the question, really, that the court has to consider. It's what is the relevance of the fact that there is an alternative route?
And let me get on to that.
Yeah.
So if we go to, fine, well, then if that is not in contention, then I can move on.
Well, I mean, it's not ousted. I mean, it's a very strong thing. I haven't seen any authority that says that it's ousted. Abbasi has quite a large part of its judgment dedicated to the question of the need to follow established routes to relief.
Yes.
But it doesn't say ousted.
No, and indeed it says that many of those routes can exist in parallel, in the sense that the concrete relief that is then granted can be made on different bases, depending on the concrete source of the power that is relied upon. And indeed, that is the point that we rely on here. And I will, if I may, shortly go into some more detail in terms of how we think that that applies in this particular case.
Okay.
Now, the second consequence of the choice of the inherent judicial jurisdiction as the source of the power for this application was, and this goes to the point that I just made, it conditions the basis upon which the application is put, which in its turn conditions the evidence that is necessary to support it. In this case, given that we rely on interference with the court's process, what we need to establish is a prospective risk to the court's process being interfered with. And finally, the choice of this power necessarily conditions the exact form that the relief the court can grant. And so on this very point, my Lord, about what is the effect of the existence of potential alternative bases for the relief sought, my primary submission is that although the material effect of the relief sought can be obtained under different jurisdictions, that does not make these alternative jurisdictions in reality alternative or indeed duplicative. And this, in my submission, becomes clear when one analyzes the relief sought through the prism, precisely, of the power that is invoked. And if we can start then at paragraph 45 of Abbasi, tab 53 of the authorities bundle, it'll be page 1205 of the PDF, page 1202 of the bundle.
What paragraph are you going to want to take us to?
45.
45.
And what in my submission the Supreme Court is doing in this paragraph, it recognizes or acknowledges that a particular fact pattern may disclose several rights and interests which the court has different powers to address or protect. And we can see here that these powers on these facts included the welfare of the child under the court's protection, the ability of the trust to perform its statutory functions, and indeed the right of privacy of the clinicians. Now, addressing one right or interest with one type of remedy may, without offending any principle, at least partially and as a side effect, provide some protection for another right or interest. But obviously that protection, as it were, the incidental protection, will then be and remain conditional upon the remedy remaining justified on the basis upon which it was first granted. And if we can look at paragraph 47, just over the page, that in my submission is what the Supreme Court says. Begin just under letter C. There is therefore an overlap between the child's interest, the interest of the trust, the interest of the clinicians in preferring rights of the clinicians in preserving their own anonymity so as to avoid violation of their rights. That overlap has an important consequence. By protecting its own interest in the anonymity of the clinicians, the trust can also incidentally protect the clinicians' private lives, and so long as the child continues to live, the court can do the same by protecting the interest of the child. So another way of expressing this is that the material effect of the relief sought can be either the ends of the jurisdiction in question or the means by which the ends of the jurisdiction are achieved. And so if I can, again, use Abbasi and the facts of Abbasi as an example, the material effect of the relief sought was the anonymization of the clinicians. Now, if the hospital trust relies on its inherent parens patriae jurisdiction or the Broadmoor jurisdiction, the anonymization of the clinicians is, in my submission, the means by which the purpose of the court's power or jurisdiction is achieved. But it is not its ends. The ends in these two cases would be the safeguarding of the welfare of the child in relation to the parens patriae jurisdiction, or in relation to the Broadmoor jurisdiction, the ability of the hospital trust to perform its statutory function. And on the other hand, in any action brought by the clinicians to safeguard their right to privacy, for example, their anonymization would itself be the ends of the jurisdiction exercised. And so therefore, if we come back then to the submissions that I made earlier about the importance of identifying the jurisdiction invoked, because each jurisdiction corresponds to a different purpose, it is in my submission contrary to principle to consider the material effect of the relief sought in isolation and ask whether it could be granted pursuant to a different jurisdiction. The proper approach in my submission is to identify the purpose of the jurisdiction or the power that is relied upon, and then assess whether the relief sought is justified by and properly tailored, both in its scope and its duration, to achieving that purpose. And so then if we transpose this onto the present case, the material relief sought is the prohibition on the respondent from sending, and I paraphrase, abusive correspondence to the appellant's legal representatives. The jurisdiction or the power invoked in support of this is the court's inherent jurisdiction to control its process. And so it follows in my submission that the material relief is the means by which the purpose is achieved. It is not itself the end of the powers of the jurisdiction invoked. To put in other terms, abuse is only sought to be prevented to the extent that it interferes with the process of the court, which is the purpose of the relief sought. And so I pause merely to add a parenthesis. The fact that interested third parties will benefit from an order or injunction is not a reason not to grant it. In my submission, if anything, such beneficial side effects should weigh in favor, at least on the margins, of the court granting an order sought. So I close that parenthesis. And if the court is with me on this analysis, distinguishing between the material relief sought as means to achieve the purpose and the ends of the purpose itself, in my submission, two things follow. The first is that the potential availability of alternative powers for the material relief sought is not as such a relevant consideration, because it confuses the material relief as the ends of the powers invoked with material relief as the means by which those ends are achieved. And second, the flip side of this proposition is that the existence of an alternative power or jurisdictional basis for the relief sought is arguably only relevant to the extent that there is identity of purpose for the jurisdiction invoked. And on the last occasion, it was put to me by my Lord Justice Warby that the statement by Lord Morris in Connolly, which we relied upon and continue to rely upon as a statement of the extent of the court's inherent judicial jurisdiction, may in reality have concerned the court's jurisdiction to prevent conduct which would amount to contempt of court. And this just to show that we have the transcript in the bundle. It's in the supplemental bundle tab 8. Page 239 of the bundle, so page 242 of the PDF.
So what are you referring to? Are you referring to Connolly or are you referring to the supplemental bundle? And if so, to what document?
I'm referring now to the proposition that was put to me by my Lord Justice Warby last time, that in reality, the power that was referred to in Connolly, and that we rely upon as a statement of the extent of the inherent judicial jurisdiction, was in reality an expression of the court's power to prevent conduct which would amount to contempt of court.
Yes.
So, if I may rephrase this issue as whether there is identity of purpose between the court's inherent judicial jurisdiction and its jurisdiction to provide quia timet relief in relation to anticipated contempt of court. And addressing this precise issue, in my submission, the authorities disclose several reasons why these jurisdictions are and should remain discrete. So in the first instance, the authorities discussing the inherent jurisdiction from Cocker and Tempest and onwards do not frame it in terms of preventing contempt of court. And second, if one looks at the type of relief that have been held as being available on the basis of the inherent jurisdiction, they certainly include matters which are very difficult to put in terms of contempt of court.
So your case, I mean, just to be clear,
Yes.
is that you are not asking us to restrain a contempt of court, and you did not ask the judge to restrain a contempt of court, and you say whether or not it would be a contempt of court is irrelevant.
That is right, yes.
Right.
I'm completely with you on the proposition that the inherent jurisdiction to do what is necessary to ensure that a court operates as a court of justice is not limited to restraining conduct that would amount to a contempt of court. I've read the transcript of what I said. I don't think that's what I said. What I said was that this is probably the jurisdiction that enables a court to grant injunctions to prevent conduct that would amount to contempt of court. That's saying that the inherent jurisdiction includes the power to restrain contempt of court, not that it's limited to that.
Very well.
So I think we're maybe at
Fine.
cross purposes. I mean, let's take Taylor and Lawrence, which is one of the cases cited in the passage that you showed us before. That's the power to reopen a previously decided appeal in exceptional circumstances. Absolutely nothing to do
Yes.
with contempt of court. Obviously, you could multiply examples like that. So you're pushing an open door with that proposition.
Very well. And so I think it might be useful then, because it follows in my submission that it wasn't necessary for us to show that the conduct would have amounted to contempt of court, or did amount to contempt of court, in order to, as it were, trigger the power under the inherent jurisdiction to make the order sought.
Yeah, but the point that I would put to you is where you are in the territory of interference with the course of justice by putting someone off their stride or making them incur excessive expenditure, then you are in the territory of the sort of thing that comes within the contempt of court jurisdiction. And the question then is it relevant to consider whether that conduct would amount to contempt of court, and if so, would be restrained. And if the answer is no, does that have any impact on the exercise of the jurisdiction that is not limited by that?
That question makes me very grateful for the authority that my learned friend Mr. Donnell submitted overnight. If we can look at, that's a single PDF, case of Attorney General against Ebert. Paragraph 33, so we're looking at pages 9 to 10 of the PDF. So that Mr. Garner told us that although it might well be that Mr. Ebert's conduct justified committal for contempt, the Attorney General took the view that it would be preferable to regulate his future conduct rather than to seek to punish his past actions. Mr. Ebert disputed that the Attorney General was entitled to adopt this approach and invited the court to direct him to take committal proceedings, but we see no reason why we should adopt this course. It is for the Attorney General to identify the relief he seeks, and not for this court to dictate to him what he should do.
Sorry, can you just give me the paragraph number you were at?
33.
Slightly different though on the facts, isn't it? Because the issue there was, should there be punishment for what has happened in the past or some regulation as to the future? And you're not, there's no question of you seeking punitive sanctions. It's all about restraining future conduct. So we are in the same territory that the Attorney General was in Ebert.
We're precisely in the same territory that the Attorney General was in Ebert. I suppose it flows from, if we, and I apologise if we were talking at cross purposes in relation to the previous proposition, but it also, it matters to the extent, if it were a requirement, as it were, for the jurisdiction to be engaged, that it be proved that the conduct in question would constitute contempt of court. In this instance, that would in effect have put a requirement on us as the claimant to prove that the conduct which we relied upon in the past, and effectively that we said there was a risk would recur in the future, that conduct did amount to contempt of court. And my submission is that it is not a requirement in these circumstances for the claimant for relief of this kind to establish those circumstances.
I'm just wondering whether it would just seem potentially relevant. The contempt of court jurisdiction to punish is circumscribed to ensure that people can do all sorts of things that may be objectionable to people involved in litigation without fear of sanction. So there's a relevance, surely, there. Particularly when one bears in mind the immunity that my lord has referred to. It would be perhaps odd if conduct which had some impact on a party's ability to conduct litigation, but was not a contempt of court and fell well short of it, could nonetheless be restrained by an injunction, the breach of which would result in proceedings for contempt of court of a different kind, namely breach of a court order. It seems a little discordant to have
Well, Lord,
situation.
I'm with you with respect up to a point. In the sense, the courts up and down the country make orders which condition conduct for the future. In that conduct which would be perfectly lawful, were it not for the order that was made. I mean, it's perhaps an extreme example, but PMC is indeed such a case. But for the order that the court made restricting reporting of what occurred in court in PMC, there's no question whether that would be lawful conduct.
No, but my point is that the objective here is the same. The objective is to protect the course of justice from interference.
Yes.
That's what the contempt of court jurisdiction is about, largely. The type that we're
Yes.
focusing on here as an analogue. So coming along and putting a person, harassing a witness on the way to court, doing something that's liable to make the course of justice more difficult to attain. That's the kind of conduct we're talking about. So that's why it's a narrower question than the one you've just raised with me.
The part of this, and I'm not sure to what extent you would find it helpful to go into it, but on the last occasion you also challenged me on the proposition that the criminal contempt has an element of specific intent. But that goes to the wider point in the sense that what the court certainly can do is, if it has evidence upon which to make a finding that as a matter of fact the court's procedure has been interfered with. In my submission, that is enough to trigger this jurisdiction without the court needing to concern itself with wider issues such as whether contempt proceedings could have been justified on the same facts, or whether, and once that has been made, the court has effectively made a very clear rule: this is the sort of conduct in which you may not engage, and if you do for the future, quite apart what happened in the past, the court's contempt jurisdiction will be triggered. I don't see any difficulty in principle with that, in the sense that on the same basis that the court can make all kinds of rules for the future conduct of litigants, which if they are violated will result in civil contempt proceedings, that it should not be able to do that in relation to conduct which, as a matter of fact, and any other considerations apart, it has found interfered with its own process.
Thank you very much.
Now, do you want me to complete my submissions from the last occasion on the intention element, of specific intent on?
I'm content to leave it to you. I can't remember what the debate was before, but your proposition is very clear,
Yep.
that the court has power to act where, as a matter of fact, the proceedings have been
Yes.
interfered.
And this is again, the proposition last time was that it would have placed an additional, you would say, quite significant hurdle, which was unnecessary in the sense that it's at least arguable that in order for contempt on this, criminal contempt on these facts, would have required proof of specific intent. And on the basis of Crossland, my lord, you challenged me on the last occasion whether that is something that's true. Now, it may be that this is by the by, but I'm perfectly happy to go into it in some more detail.
Well, let's see if it's controversial.
Very well. So, in the reference that, my lord, you took me to on the last occasion was Crossland. If I can take to Crossland number 1, at paragraph 23, and that you will find in tab 42 at page 837. So, my lords, you will recall, my lady, you will recall that in Crossland the issue was an order had been made, effectively that this is a draft judgment under embargo, and there had been violation of the embargo by one of the representatives in the proceedings. And so you can see at paragraph 23 here, if I could be in at the second sentence, where the present case is not a case involving a breach of an order by a party to litigation where the order has been made at the instance of an opposing party, and its purpose is simply to protect the private rights of that other party. Rather, the order was made in order to protect the administration of justice, and its breach involves a general interference from which the administration of justice must be safeguarded. And so, my submission is that in this case, the Supreme Court's finding on specific intent was in the context of the fact that the contempt alleged was in reality hybrid. It was the violation of a court order, albeit not an inter partes order, but one imposed by the court in the interest of justice. And I think we can see that if we go down to paragraph 28, where the court says, so far as the mens rea of criminal contempt of court is concerned, we are satisfied to the criminal standard that the respondent's breach of confidentiality was deliberate and in breach of a court order of which the respondent was well aware. In our view, that is sufficient for present purposes. It is not necessary for the appellant to prove an ulterior intention to interfere with the administration of justice. However, in any event, we are also satisfied to the criminal standard that in publishing the judgment in breach of the embargo, the respondent did have a specific intention to interfere with the administration of justice.
Well, the ratio is that it wasn't necessary to prove an ulterior intention to interfere with the administration of justice.
So
the case is in your favour.
Yes, but in this case, and I said this is not, I will submit a general proposition as to the absence of a requirement for specific intent in relation to contempt on the basis of interfering with the administration of justice. The other case that I wanted to take you to, because it was part of the cases, it was one of the cases that Your Lordship wanted us to address, the case of Jordan. That's at tab 52, and the relevant paragraphs are paragraphs 24 and 26, page 1174, and page 1177 of the PDF. And there the Court of Appeal says that this case is concerned with what is generally known as contempt in the face of the court. And then if we go down to paragraph 26, we read that paragraph. In my submission, it's clear that what the court is considering is the specific branch of criminal contempt which is in the face of the court. And I think that is further supported by paragraph 43 of the same judgment. That would be page 1181 of the PDF, 1178 of the bundle. And I quote, "There is, however, a prior issue, namely where the specific intent is an ingredient of this species of contempt of court." Now, in my submission, neither Crossland nor Jordan expressly or impliedly dealt with or sought to question prior authority which addresses the requirement for specific intent for criminal contempt of court generally, it being understood that the scope of the potential conduct court is open-ended. And so if we look, for instance, at Lord Denning's judgment as Master of the Rolls in Attorney General of Butterworth, so that's tab 16 of the authorities bundle, page 149. It's the final paragraph of the on that page, beginning with "I think." And now the point that in my submission is being made there is that specific intention was in this instance required to distinguish between conduct which could be perfectly legitimate. So that is what he says as he continues. "It is easy to imagine cases where the dismissal of a witness from his employment, as it happened in that case, or his suspension or expulsion from a trade union might well be done and justified for reasons quite apart from the evidence he has given. And that clearly would not be contempt of court. It seems to me that the intimidation of a witness is only a contempt of court if it is done with the purpose of deterring him from giving evidence or influencing him to give it in a sense different, etc." And in my submission, the same point was made by Lord Simon in Times, as it's referred to in your judgment. That's the Times 1, as it were, the thalidomide judgment. That's at tab 19 of the authorities bundle. You go to page 327 of the PDF, 323 of the bundle. And at B, there's effectively a distinction between different kinds of pronouncements that are made in public or different publications which affect or deal with something which is being dealt with in ongoing proceedings. And he refers to an Australian case. Lord Simon refers to an Australian case of ex parte Dawson, and it italicizes a distinction that is made by, forgive me, I don't know what the judge's name in the Australian case, but what is said is that the discussion of public affairs cannot be required to be suspended merely because of the discussion may, as an incidental, but not intended by product, cause some likelihood of prejudice to a person who happens to, at the time, to be a litigant. And if we then go to the second Times case in the bundle, the Spycatcher Times, that's at tab 23 of the bundle, page 215 of the report, which should be at page 420 of the PDF. This is Lord Ackner, who cites with approval from a judgment by Lord Justice Evely in Z Limited in relation to contempt by aiding and abetting the violation of a court order. And if I could ask your lordships, my lady, to focus on proposition 2 from Evely's judgment, which is at D on that page, beginning, a third party and the emphasis there is that the assistance in the breach needs to be knowing and willful. And then the conclusion that Lord Ackner draws from this is at page 218 of the report. If we go down 4 pages to page 421 of the bundle, right at the top, there is, however, this essential distinction that his liability is for criminal contempt and arises not because the contemptor is himself affected by the prohibition contained in the order, but because his act constitutes a willful interference with the administration of justice by the court in the proceedings in which the order was made. Here the liability is not strict in the sense referred to, for there has to be shown not only knowledge of the order, but an intention to interfere with or impede the administration of justice, an intention which can of course be inferred from the circumstances. So, I hope to have demonstrated that on our present facts, and it is enough for my present purposes, that it would certainly have been arguable that in order for Miss Okunola to be held in contempt of court on account of the communications in evidence, or indeed future communications of a similar kind, specific intent would need to be demonstrated, and also to a very high standard, so that the court is sure. And so as a matter of procedural economy, again, this is the argument why, in order for the court to be able to regulate its own procedure purely on the basis of observed effects of interference with proceedings, it is a very different proposition to prove that that conduct would have constituted contempt of court. Well, also, my lady, I know we had an impromptu break. It's 12:15. I'm perfectly happy to press on till...
We don't take breaks.
So with that, I then come on to my third topic, as it were, whether the court, or whether Mrs. Justice Hill could and should have granted the relief sought in this case. Now, the question then is whether Mrs. Justice Hill erred in refusing to make the order. And on the one hand, this court has already indicated that it's agreed that she erred in finding that she did not have the power to make it. And so as we stand here today, some 18 months later, there are two separate questions. And the first one is whether Mrs. Justice Hill, had she addressed the relevant principles, erred in not making the order then, and on the other hand, whether the Court of Appeal, as we stand here today, should make the order sought today. And this allows me to address several questions in the court's note. And in my submission, the starting point is that the inherent judicial jurisdiction has no other limit other than that the remedy sought must be justified by an established or anticipated interference with the process of the court. And in relation specifically to interference with the work of a party's lawyers, the issue this is the very issue that underlies this appeal. There is, in my submission, a primary consideration of forensic reality. And that derives from the essential role played by lawyers in ensuring that litigation is conducted in line with the overriding objective. The overriding objective is obviously targeted at enabling the court to exercise its societal function of adjudicating disputes. And in representing a party to litigations, solicitors do so in their capacity as officers of the court. In that capacity, they have duties to assist the court in meeting the overriding objective. And these are duties that they owe directly to the court. And while it is obviously the case that interference with the ability of solicitors to fulfill their mandate in litigation will be injurious to the interests of their clients, and sometimes, as in this case, arguably violate their personal rights also, it is also inevitably an interference with their ability to fulfill their duties as officers of the court. And it follows, in my submission, that interference with their ability to fulfill their mandate in litigation is an interference with the court's ability to exercise its function in line with the overriding objective. And so I would take the court back to what Lord Justice Phillips, who's Master of the Rolls, said in Bamji and Fordstick at paragraph 15, that the court has the power to take appropriate action whenever it sees that its functions as a court of justice are being abused, those functions being more precisely defined and elucidated in the civil procedure rules. And so I would certainly endorse what the learned advocate says in his skeleton at paragraph 19. That is in the supplemental bundle, tab 7, page 209 of the PDF, page 206 of the bundle. In particular, I endorse the reference to the case of Runting at paragraph 20b there. And with that said, by way of introduction, I come on to...
That's about going backwards and forwards to court without being molested.
In that case, yes, that is what it says.
So what are you endorsing? That they said that in Runting?
I endorse the general proposition that any interference with solicitors' ability to carry out their duties in the course of litigation, whether that be by assaulting them or walking up to them and disturbing them, walking to and fro court, or whether that is by inundating them with, as in this case, a torrent of abusive communications. It is part and parcel of the same jurisdiction. And in terms then of the test for the relief sought, In my submission, relief should be granted under the inherent jurisdiction is when it is necessary to guard against the interference with the court's process that has been identified. And that is consistent with what the Supreme Court said in Abbasi. We can go to paragraph 165 of Abbasi.
165.
165, which is tab 53, page 1239 of the PDF, 1236 of the bundle. Says that we respectfully agree with the court's conclusion, the Court of Appeal, that the High Court had inherent jurisdiction to grant the injunctions at the outset of the proceedings under its parents' patriot powers, and this is the important bit, could also make such orders as it considered necessary to protect the integrity of the proceedings themselves. So necessity being the test for the inherent judicial jurisdiction. And so in relation to the test, if I can develop what was said at paragraph 27 of our original appeal skeleton. Just for your note perhaps, that is in the core bundle at tab 2, pages 37 to 38 of the PDF, 34 to 35 of the bundle. So in my submission, this breaks down as a 4-stage assessment.
Sorry, 37 is the submissions of the advocate to the court in the core bundle.
So we're looking at tab 2 of the core bundle.
Page 34, isn't it?
34 of the bundle, yes. If I say that this is what I'm about to say, the test is a development upon what we submitted there. So the first stage would be, has the application established a material risk of interference with the course of justice? The second stage, or the second question, would be, is that interference sufficiently serious that the court's intervention can be deemed necessary? The third question...
We'll take it slowly. This is not in your skeleton, these tests, are they?
No, it's not.
Is that interference sufficiently serious? What?
That the court's intervention can be deemed necessary. Third question, would the relief sought address the interference so identified? And finally, fourth stage, balancing the seriousness of the interference identified against any countervailing rights and interests, is the relief necessary in the interest of justice? And at that fourth stage, it will be clear that the weightier the countervailing rights and interests, the more severe the interference with the course of justice would have to be.
Sorry, just say that again.
So at this fourth stage, when you balance countervailing interests against the seriousness of the interference, it is obviously the case that the weightier the countervailing rights and interests are, the more severe the interference with the course of justice would have to be in order for the relief sought to be deemed in the interest of justice. And so taking PMC as an example, obviously the interference that was there identified is of a different order to that which has been identified in the present case. But equally, however, and as I will get into, the countervailing interests are nowhere near what they were in that case. And so, if I can then go on to apply those stages.
So, what are the countervailing interests?
Well, the court has identified freedom of speech, and immunity, potentially, in litigation.
Yeah. What else?
Well, those are the ones that I have identified. So if I can go back then to apply this to the exercise that was faced then by Mrs. Justice Hill, or the one that Judge and Mrs.
Where do you put into the balance the fact that every litigant in the land tries to make the life of the solicitors for the opponent difficult?
This is I would say, in the sufficiently serious category, and I try to explain this with reference to whether it is appropriate to consider making life difficult for solicitors for tactical or strategic purposes in litigation that can be remedied by way of costs, which would be where we are going there. And costs are the price you pay for being unsuccessful in litigation. But in my submission, it rather presupposes that that is what you have been engaged in.
So what's your point on costs?
The starting point, my lord.
Is that another test?
No, it's. I mean, given that the question was put to me in the sense of, well, where does it fit in? It fits in at stage 2 in my submission, whether it's sufficiently serious to warrant the intervention of the court.
Costs fits in there.
Well, the sort of conduct to which your lordship took me to, in terms of what solicitors or parties to litigation try to make life difficult for each other, that usually, if it is properly within the scope of the conduct of litigation, is what is compensated for in costs. If you are unsuccessful, you will pay the others, and if you are being very unreasonable or deemed unreasonable, then you can have an indemnity cost made against you. That is obviously how that kind of conduct is policed. Both parties, both sides will know what the risks and benefits of a particular...
Well, it might be said against you that an international firm of the scale of your clients could have put in place firewalls to ensure that every email was scanned by an appropriately resolute person, and only the only the substantive points made by the litigant in person would be passed to, I think it's Mr. Galani, and the costs of that could have been recovered in the litigation because they were necessary.
A couple of points on that. That is indeed what the solicitors had to do and did.
They actually did that. That's in the evidence. Can you
They
give me the reference?
Yes, I will come back to it when I have a specific reference point, but that is indeed what had to happen. There was, however, a risk in proceeding in that way, which eventuated on the facts of the case, and that was that the things were missed, to put it bluntly. There were documents, was in particular an important document, which was not put in a bundle, which it should have been before Mrs. Justice Hill, because it had been missed in the torrent of emails that was sent and upon which reliance is placed. And so, even if it is right that, from the point of view of the solicitors, technical protective measures, if I can put it that way, could and indeed were put in place, but from the court's perspective, again, on the basis that we are relying on the court's power to protect its own process, that was not, in fact, adequate in order to prevent its process from being interfered with.
Was that part of the evidence before the judge?
It was, and it was indeed part of the judge's findings. Paragraph 25 of the judgment, she makes reference to that particular incident.
Sorry, she says there's no doubt the defendant's conduct has fallen very far short of the expected behaviour of litigants in person.
I apologise, my lord. The reference is right above at the end of paragraph 24, where, for example,
It led to the skeleton arguments being struck. Yeah, okay,
Yeah.
thank you.
now in terms of the reference of the protective measures for the evidence, it's in the witness statement by Mr. Galani, the fifth witness statement that was in support of the original application, paragraph 30. It's in the supplemental bundle, tab 16, page 418 of the bundle, page 421 of the PDF. And so conduct of this type should, in the first instance, be looked at, as I submitted, from the point of view of the court and what it risks doing to its process, not whether it was unpleasant to the solicitors. It is, of course, the case that the more unpleasant it is to the solicitors, the more likely it is that it will affect the court's process. But again, that is
I'm
not...
sorry, this is quite... It's not about whether it was unpleasant for the solicitors. The only question under what I'm calling the IJJ is whether it interferes with the court's process.
Indeed, and if I can come back to...
I mean, you say that.
Yes, I say that. If I can come back to the distinction that I made between the ends of the exercise of the power and the purpose for which it is exercised. The purpose for which this power that we rely upon is exercised is the interference, the preventing of the interference with the power, with the process of the court. Now, it is of course the case that the degree to which life is made unpleasant for solicitors working on a particular case will have an impact on the likelihood and the extent to which the court's process will be interfered with. I mean, to take an extreme example, if solicitors refuse to work on a case, if they simply cannot stand what is happening, then that would obviously impede the court's proceedings. But I come back to this point that the basis for the jurisdiction, the basis of the power that we are asking the court to exercise is the impact on itself.
But the interference with the solicitor's normal discharge of their duties is the mechanism, and the only mechanism that's relied on as amounting to an interference with the court's process, isn't it? And that's it. I can see the distinction in principle that you've very clearly enunciated between ends and means. But in this case, and to a degree in Abbasi, the reason for seeking the relief was, at least in part, in this case very wholly, the interests of the non-party.
I am with you, my lord, of course, up to a point. But again, if we come to for the same reason that the protection for the clinicians in Abbasi would have come to an abrupt end if reliance was made if reliance was placed purely on the parents' patria jurisdiction, once the court's protective powers were no longer at issue. In this case, no protection is sought for the solicitors as individuals. There is no protection in this order for abusive correspondence by the defendant against solicitors as individuals or outside the context of proceedings as defined in the draft order.
I didn't understand that point. I mean, then you've got to look at the form of the injunction.
Yes?
I mean, if you look at the form of the injunction, she is to be injuncted from, I mean, I don't want to guess or misremember, but we can find it fairly quickly.
Yes, I shall find the... yes, the amended...
What page is it? Not the amended version. We're talking about
the original version.
The original version. Core bundle.
Bear with us. Supplement tab 18, yes.
Sorry?
Tab 18.
Of?
Supplemental bundle, apologies. It's page 530 of the PDF,
Yeah.
527 of the bundle.
Yeah. She's prevented from publishing any message to the claimants or about the claimants' legal representatives which abuses, belittles, demeans, or insults them.
Yes. And if you look at paragraph 4,
apply until further order in relation to all proceedings, including others.
So your point is that they're limited by reference to the proceedings or future proceedings that are connected.
yes.
And
This is abuse.
Not simply on the basis you can carry on insulting, belittling, and all the rest of them if she finds a reason to do so, so long as those proceedings are not extant.
I mean, this appeal apart, if Miss Okunola, if this order had been placed and Miss Okunola had gratuitously sent correspondence which qualified or which fell within the definition of paragraph 1, that would not have been caught by this order.
But, I mean, that presumes that, the reason I asked you the question is because you said it was nothing to do with protecting the solicitors, but this has the effect of doing so during the conduct of the proceedings.
My Lord, in the same way as in a bussy, the anonymisation of the clinicians was not the purpose of the jurisdiction that was exercised under the parents' patria jurisdiction. That was the means by which the interests of the child were protected. It was, as it were, incidental to that interest which was at the heart of the court, at the excess of the court's jurisdiction. By the same token, interference with solicitors as they exercise their functions as officers of the court in proceedings as defined constitutes the limit and the rationale of the order that is sought. It does not extend that protection to the solicitors as individuals, and I think that is also clear because the absence of a schedule, for instance, nominatively setting out which individuals are to be protected. So these are individuals that are identified by their function, and if, for instance, the claimants or the appellants in this case were to change representation between this order being granted and any future proceedings, then this protection, as it were, would follow those new representatives. And so there is a line between the purpose for which the power that we are seeking, that we are relying on, and the scope of the order that was sought. And of course, to come back to, that does not mean that the nature or the impact on the solicitors is irrelevant. It is of course relevant when the court assesses the likelihood that the conduct in question will cause an interference with its process.
Can I put a couple of points to you about the threshold? In your four-part analysis, your first question is whether there's a material risk. So
Yes.
that's the basic threshold. And if that's not crossed, then you don't go further. Point two, is it sufficiently serious that the court's intervention can be considered necessary? Now, so that's a threshold of seriousness.
Yes.
It might be said that there are other relevant thresholds of seriousness in the law to which regard should be had in applying that test if your four-part approach is to be adopted. For instance, Parliament has established a threshold for harassment, which is both a crime and a tort if those criteria are met, and there are various defences to the tort or crime of harassment. Equally, in the authorities that you've taken us to, the court has repeatedly identified in the contempt jurisdiction a threshold of seriousness which is serious interference. Would you accept that this proposition, which I put to you tentatively, that if neither of those thresholds was crossed in relation to the conduct element of what you're complaining about, there would be no good reason to exercise the undoubted jurisdiction to grant an injunction?
Well, the reason I hesitate is precisely because if we look at it from the court's perspective, whether there would be defences under the Harassment Act, or whether conduct in question was done with sufficient knowledge or intention for the purpose of contempt.
No, I expressly excluded knowledge or intent.
Okay, fine. Excluding.
I'm talking about the conduct element.
Yes.
So we're talking about the effect, the impact. In harassment, the impact has to be to cause alarm or distress or other forms of harassment, or such that a reasonable person would consider that it amounted to harassment. So an objective test as to what a person in those circumstances would feel or encounter, experience. And in contempt, it's the gravity of the interference with the course of justice that is a threshold requirement. So that's what I'm trying to focus
Yes.
on.
It comes in, I tentatively offer, in when the court considers whether a material risk has been established. Because when you consider whether there is a material risk that conduct of this kind in the future would interfere with the proper process of the court, these threshold criteria would obviously be considered. For instance, if we can remind ourselves of the correspondence that we looked at in more detail than I intended previously, but that paragraph in Ms. Okunola's response to the application, where she mixes say, at least good points on the jurisdiction of the court with, shall we say, gratuitous insults to the solicitors. I think there, obviously, we would struggle, and I wouldn't even suggest that that would be adequate, effectively, for the court to find. It would be ridiculous to suggest that correspondence of that nature could lead to an interference with the court's process.
Well, then how can you injunct it?
I'm not suggesting that we should.
Well, you are injuncting it if you got this order, because this is a message which abuses, belittles, demeans, or insults those persons. That's the problem. And if I may just come back to your answer to my lord, the test you've identified is about a material risk of interference with the course of justice being sufficiently serious. Right, those are the first two elements. That seems to me to be nothing to do with the question of whether a threshold for contempt is crossed or not. whether a threshold for harassment is crossed or not. It is about whether there has been a sufficiently serious material risk of interference with the course of justice. So I think you have to say those thresholds are irrelevant under your test. Anyway, to those two stages.
Yeah, I by no means meant to disagree with that. What I said, the sort of factors that, and I took that to be Lord Justice Warby's point, that there are various thresholds, the severity of communications, for instance, which would trigger potentially other causes of action.
You see, the problem is where my lord is coming from, I suspect, is what he said earlier. I mean, he'll speak for himself. But he said, wouldn't it be odd if you could get an injunction when you couldn't get a harassment injunction and you couldn't get a contempt injunction based on contempt, but you could get one based on much lesser conduct by this route?
And my submission on that is no, it wouldn't be odd.
No, I get. But I mean, I'm putting to you that you, on your tests, completely ignore we may be wrong. I mean, don't get me. I'm not saying we're right to think these points are relevant at all. But it seems to me that you're still saying, no, your points are completely irrelevant to this. It doesn't matter that the solicitors could have got an injunction if they had surmounted the obstacles for harassment. It doesn't matter that whether or not this is a contempt. The only question is the sufficiently serious material risk of interference with the course of justice, and that being properly interfered with, proper relief designed to prevent it. And I mean, I think you do need to go that far, but the question is, are you right?
Well, granted, and if I can simply adopt my Lord's characterisation of my position, that is indeed my position, that there is no need to demonstrate that there would be harassment or contempt.
And the point that was being put to you by the court, I mean, I think we're getting to the nub of this case really, was that when considering whether to exercise the inherent, what you call the inherent judicial jurisdiction of the court to protect its own process, you need to consider not only Article 10, which is not in here at all except as a countervailing interest possibly, but also, as in Abbasi, the other possible steps that could have been taken to prevent the conduct in question. But your answer to that, if I may give it, is, well, you're starting from the wrong end, because you are ignoring the fact that the only thing that matters here is the interference with the court's process, and none of that matters if the court's process is sufficiently seriously interfered with. You should injunct it, whatever interference it makes, really, with freedom of speech or anything else.
My Lord, I'm with you up to the right at the very end, as it were. There is the first two stages are whether there is a material risk of interference, and whether that would be in principle sufficiently serious. Then, as I said, under stage 3, you have to look at whether the relief sought is targeted. So we've been through that in terms of it's limited to and adapted to the purpose of the power that is invoked. And then stage 4, obviously, we need to consider the other interests, the countervailing interests that are an issue, and whether, having taken those into account, the order can still be deemed in the interest of justice.
Can I put this to you? I mean, speaking for myself only, I find this a difficult case because I've had nearly 50 years' experience of litigation, and I know how people act in litigation, from all kinds of litigation, from the bottom to the top. And they don't always act in the way that the King's Bench Division Guide would like them to. And I have not encountered an application of this kind, precisely of this kind, before. so it seems to me that there has to be some way for the court easily to assess, because if we were to accede to your submissions, this would be a blueprint for the future for judges faced with such things. There has to be some way for them to access practically the answers to your first two questions, even if they're the right questions. Right? What is a material risk of interference with the course of justice when litigants are rude? And what is a sufficiently serious interference to trigger the court's intervention? And that, unfortunately, raises the question of what people ought to be allowed, have to put up with. What is the extent of the indemnity found in Iqbal? Because if there is an absolute indemnity and you can do what you like in litigation and you're protected against everything, as my lord explained in some detail at first instance, that must be relevant to whether or not it's sufficiently serious, because otherwise the two principles would be in conflict, affecting the same thing. So that's where I'm finding difficulty with this test, where it doesn't tackle those. I mean, I think the two critical ones, for myself, I find contempt, I'd be minded to accept that you don't have to go as far for this kind of injunction as showing that everything you're injuncting would satisfy contempt. But for discussion, I'm not sure. But assuming you're right about that, surely one approach is to say free speech is crucially important. Article 10 protects people, freedom of expression. You get immediate, must be engaged when you're trying to get this kind of injunction. Forget 12.3 because it's a sort of final injunction. And question is proportionality. And at that stage, you have to consider all the factors that we are talking about. Now, do you accept that?
Yes. Yes, I mean, that is part of the test that I have formulated.
So that's countervailing interest?
Yes.
Yes. I mean, it's not, if I may respectfully say so, very helpful to the poor old judge who's on a Thursday afternoon, comes into court and is presented with used to be a carrier bag full of abusive emails, and said, look at this, judge, isn't this awful? We have to put up with this. You must injunct it. And the judge surely needs to have some fairly clear guidance as to what Quinn Emanuel really ought to be able to put up with in an isolated inbox and what it shouldn't.
Yes, and so I think these...
Well, you say that's the wrong question. You say what interference in the court's process ought to be had to put up with. But I mean,
yes,
it's it might be said against you that this looks more like an injunction restraining people from abusing Quinn Emanuel than it does an injunction to protect the process of the court.
and indeed that was the point that was effectively made against us by Mr. Justice Hill.
Can I, Mr. Leaf, can I just check that I've followed back on your four-piece approach? It sounds to me, having listened to the debate, I think what you're suggesting is that this is a power, so whether to exercise the power is a discretionary decision in the end for the judge, but the judge is to be guided by the criteria that you set out at your four stages. And I think where we are is that stages 1, 2 and 3 are really threshold considerations, in other words, knockout blows if they are not established. So if there's no material risk of interference in the future, then it goes. If there's not something that's sufficiently serious, which is just a sort of a yardstick idea, then we don't worry about it. If it's trivial, de minimis, you don't worry about it. And if the relief that's being sought isn't apt to the thing that is feared, then it goes. So actually it's all in number 4, which, as you've discussed it, is actually a proportionality exercise of working out whether it would be proportionate or not to grant the relief that is sought in the circumstances. And perhaps the issue that we need to really concentrate on is whether in in looking at proportionality, or what is just and appropriate, or whatever language you want to use, or in the interests of justice, you take into account at that stage what other measures might have been available and the sorts of thresholds that would have applied if, for example, the solicitors had sought to protect themselves under the Protection from Harassment Act, that sort of thing. And it's all in the wash at that stage. Does that... I think you'd still say, no, you don't go to harassment and you don't go to contempt at that stage, but that may be where we need to focus our thoughts. I think my question to you, long and baggy, is do you accept that kind of ranking of your four-piece sequence?
No, I do, and I think that the reason why I put it in that order is because before you can engage in any kind of proportionality exercise under, for instance, Article 10, you need to know what it is that you're putting in the other scale.
Yes, and think about that over the adjournment. Can I just deal with timing? And obviously, we don't have the respondent, but we do have the advocate to the court. Have you talked about timing?
No, well, to the extent that I have, yes, we have broached it.
Well, how long do you think you're going to
Well, I'm hoping that I'll be able to sit down not very long after coming back in the lunch break, which
Okay.
hopefully will.
That's fine, but then will be plenty of time. Might even finish today. Right? The things that I would like you to think about is whether your test really helps judges enough, bearing in mind your acceptance that proportionality under Article 10 is important, even if the contempt test doesn't have to be satisfied. But then question, where does the immunity jurisdiction come in? Where do you evaluate whether this is protected by that immunity? Question, what is the law? Because Iqbal is a first instance decision of my lord. We haven't heard argument on it, so it might be difficult for us to say that's absolutely marvellous in every way without argument. And it would be good to clarify the answer to my lady's question as well. So anyway, we'll resume at 2 o'clock and see where we get to.
Can I make an offer to the court? I have been told to offer that we can provide repaginated bundles over the lunch break, if that would be
I'm
of
afraid
assistance.
that won't work because I've already got notes that are the unrepaginated version. It won't work for me anyway. So
No,
thank you very much then.
Thank you.
Um,
Stay.
2 o'clock.
Court rise in favour.